Thank you, everyone. I really appreciate you being here on a Thursday night. Again, my name is Sophia Gallardo. I'm an estate planning attorney here with the McGovern Law Group, and very excited to be presenting on estate planning and the importance of avoiding probate here. Before we dive into that presentation, just a little bit about me. So I grew up in Chula Vista. I was born and raised there in Chula Vista, South Bay. I'm happy to be working now in East County. Yeah, go Chula Vista. I do speak Spanish, so Spanish was my first language. My parents put my sisters and I in kindergarten, and we got picked up from school. My teachers came up to my parents and said, I could not communicate with your daughters. They only speak Spanish. Start teaching them English at home. So thankfully I have bilingual parents. They taught us both how to speak English and Spanish. So thankfully I do speak Spanish as well. I did recently join the McGovern Law Group. I joined in July, but I am not new to estate planning. I have a little over 2 years of experience focusing solely on estate planning and probate administration. Some fun facts about myself is I am an identical twin. My twin sister is not an attorney. She is a pediatric physical therapist, so she works with kids all day. I also went to school on the East Coast, so after high school I went over to Philadelphia and studied over there for 4 years. I did go with my twin sister and younger sister, who's only a year younger, so it was awesome to experience the 4 seasons, get away from San Diego for a while, and then come back for law school. And lastly, I am involved with my church. I'm a practicing Catholic, so I love being involved with my community. I did make all my sacraments at Corpus Christi, so it really makes it nice to have a good home base there. So let's go ahead and dive in. So we're going to be talking about what happens in California if you pass away without validly creating an estate plan. So California has already set up default rules that tells us exactly what's going to happen if you pass away without validly creating a trust and a will. So this is known as intestate succession, which is just a fancy word for saying you have died without a will. So what this means is if you pass away in California with assets held in your individual name, and that asset is worth more than $184,500, it can trigger probate. So for example, if I own a home in my name alone, and I pass away and that home is worth $800,000, then my family is going to have to go through the court process to receive that home. So we're going to talk a little bit about what are these problems here with probate. So first one is time. You probably have heard that anytime you're going through the courts, it's going to take a while. And that's true here with probate as well. So it takes a minimum of 12 to 18 months to close a probate matter. For example, me and Sam are working on a probate matter right now where we filed this petition in August, and we don't have our first hearing with the judge until December. And it's a very straightforward case, so again, it's still going to have to go through that long time period. The next thing is it's a public process. So of course, if you're going through this court system, it is going to be public. If you were to just search the first and last name of that individual that passed away, you'll find the assets of that individual, the children that are going to be receiving that inheritance, maybe any creditors that that estate has. Again, it's a public process here. And then lastly, fees. So I made a couple of slides on this one just to harp on the fees here that are involved with probate. So again, California already has these default rules in place that tells us exactly how much an attorney is going to get paid when we go through probate. So first, they'll take the total value of your assets at that date of death valuation, and they'll use this formula. So they'll take 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then 1% of the next 9 million. So again, let's use that example. I own a home here in San Diego. It's worth $800,000. I pass away, and now my family has to go through probate to administer that estate. So in order to get that home, well, let's see how much the attorney is going to get paid here. So we plug in that formula. Again, I went to law school to not do math, but here I am doing math, so check my work. But what I ended up with was $19,000 in attorney's fees. So that's just solely going through that probate process here that comes out of your estate instead of going to your loved ones. But that's not all. We also have in California, a judge has to appoint what's called an administrator to allow this person to manage your estate and administer your estate and your affairs. that person is also entitled to $19,000. So you're looking at about $38,000 to $40,000, again, depending on the value of your assets. This example just used one asset, which was a home. So it could be worth a lot more than that just to go through probate. Hopefully that scared you a little bit as to why we want to avoid probate, but I think one of the best ways to conceptualize something is to get a story or an example. So we're going to look at Dan and Wendy's family tree. We're going to go and dive in a little bit into family information, kind of what we would gather here from a client. So we have Dan and Wendy. They were married for 25 years. They each had children from a previous marriage. So we have Dan, who had Allie, and then Wendy had Ben and Carly. We're told that Dan and Wendy own their home together as joint tenants. They were also told that that home was worth $800,000. Dan passed away in 2022, and Wendy passed away in 2023, a year later. We're also given a little bit of information on family. So again, they're a blended family, but they did not, Wendy and Dan did not adopt the other's children. They just loved them and cared for them as their own, but they had a good relationship with them. We have that Allie moved in with her father and Wendy to care for them, support them, really be their primary caregiver for 10 years. Yeah, she actually sold her own house to live in there with her father and Wendy. And then we're told here that Ben, so you see that slash there, he passed away. Ben had a daughter named Bianca. She's 16 years old and is looking forward to going to college soon. And then we have Carly here, who is out in New York trying to figure out her life as a aspiring actress here, so she just wants to make some money. So the big question here with this family tree is who is going to receive that house that was held in joint tenancy between Dan and Wendy? So in order to answer that question, we have to figure out what joint tenancy means. So what this means here is if you own a home as joint tenants, husband and wife, let's say in this example, you both own an interest in that home. So Dan owns 50%, Wendy owns 50%. Upon Dan passing away, his interest automatically gets transferred to Wendy. So we have that example there where we see 100% is now in Wendy's name. So hopefully some alarms are going off in your head where we know, number one, that house is now held under her name alone. Number two, that house is worth $800,000, so that triggers probate, right? So we know, okay, that house now belongs to Wendy. Now how do we distribute that to her heirs? So we go one step further here and we talk about rules of intestacy. So again, California law already tells us who is going to receive your inheritance if you don't have a trust and a will in place. So there are three categories that you can fall under. That first category is if you are single and you pass away with children, then your children are going to receive your inheritance or your assets in equal shares. That also includes if you have a child who predeceased you, but they have a child, that person will also receive that inheritance that your child would have received. So I'll get back to that in a little bit with that example with Dan and Wendy. The second category is if you pass away, you were married and had no other heirs. So for example, let's say that you never had children, your parents passed away, and you were an only child. So your spouse, your surviving spouse, will get everything, your separate property and your community property. That third category here is if you pass away, you are married, you left a surviving spouse, and you have some children here. So that will be distributed community property, anything you acquired during the marriage will go to that surviving spouse. Separate property will be divided between your spouse and your children, depending on the number of children you have. So again, these can get a little complicated, but we're going to focus on the first category here because that's where Wendy falls under. So if we move on to that family tree again, we see that Wendy now owns the home 100%, as we saw with joint tenancy. So that means that her share of that home, or the entire home, would be divided between her children. But we see that Ben has passed, so his 1/2 share is going to go down to Bianca. So to answer that first question here that says who receives that property, it'll be Bianca and Carly in equal shares. So hopefully you see that there's a negative consequence here in that we're completely leaving out Allie in this situation here with intestacy, right? We know that Allie put a lot of time and money into caring for her parents, living with them, probably using a lot of her own money to satisfy the mortgage payments, take care of them. But because of that joint tenancy that automatically transferred Dan's interest to Wendy, Allie is completely out of the picture, right? So we'll go back just to see that again. Allie was solely Dan's wife. When his interest automatically transferred to Wendy, Allie's left without the home, right? So again, that likely was not Dan and Wendy's intent here to leave Allie out. They're probably wanting to provide for all of their children in equal shares. We know they had a good relationship with all of them. So their intent is likely not going to be upheld if we go through probate. We also saw that Bianca was a minor. That granddaughter is 16 years old. Now she's not able to receive that inheritance until she turns 18. But again, giving an 18-year-old an outright distribution, half of an $800,000 home, likely not a good idea, right? So again, also keep in mind we're going through probate, so they still have to go through the time process here. It's still a public process, and those fees that we discussed are also associated with this distribution, okay? So hopefully, again, that scared you a little bit more when it comes to probate here, why we want to avoid probate. So let's get to the happier side as to how can we avoid probate here, and we can do that with a trust. So a living trust here is a legal document that allows you, the grantor, the creator of your trust, to appoint a trustee or a manager to manage your trust on behalf of you and on behalf of your beneficiaries. I know I threw a lot of big terms out at you. Essentially, you are in control when you establish a trust. So one of the best ways I like to describe how a trust can effectively avoid probate is in a two-step process. That first step is to establish and create your estate plan. You're kind of doing that first step now by hearing about what a trust involves and why we want to create one, but it also includes you designing your plan. So you tell us, who do you want your successor trustee to be? If number one, you have a mental incapacity event during your life, who's gonna step in to manage your trust assets, right? Your home, your bank accounts, who's gonna step in there and do that on your behalf? Who do you want to name as people to receive your inheritance, so your beneficiaries? Do you want to give them age intervals, right? If you have a daughter or a son and you want to say, I want to give my daughter 1/3 when she turns 21, another third when she's 25, and maybe another third when she's 24, right? You are in control of those assets and how they're distributed here. Part two, very important here, is to fund your trust appropriately here. So what this means is we want your assets to be properly aligned here with your trust. So for example, that with Wendy and Dan holding that property here in joint tenancy, we would have asked them to convey their property to their trust. So the two of them as trustees of their trust, that avoids probate because they're no longer holding that asset in their individual name. So that's what that means, is we want, again, your assets to be aligned with the name of your trust here. So step one, establish, create your estate plan, design it. Step two is incorporate all those assets into your trust here to avoid probate. So again, we're gonna just apply that scenario that we discussed here with what we know now about trust. So if Dan and Wendy would have come to us and said, hey, this is the situation that we're in, this is our blended family and our assets, how can we effectively distribute this to our family? So again, we would have discussed here the beneficiaries. Allie is contributing to the home, she's living there, it's her personal residence as well. Maybe they want to gift her that property, or maybe they want to distribute a little bit more proceeds to her as a thank you for helping them, right? But at least we know in this case she won't be left out, as we saw with intestacy. Again, there's an option for those age intervals here. So if there are ever any minors that end up receiving an inheritance, at what age do you want them to receive it? Maybe instead of 18, like we saw with court, we can do 25, right? Again, another feature here with a trust that you don't see with a probate process is we provide for contingencies. So for example, we say, who do you want to receive the property? And they say Allie. And we ask a follow-up question. Well, if Allie passes away, who then do you want to receive the property and in what way? We provide for backup or contingent beneficiaries here. Again, allowing you to have control of your assets and where they go. Again, step 2, funding your trust. We would have asked and would have highly encouraged and helped Dan and Wendy execute a deed that instead of their house being held under joint tenancy, would have been transferred to their trust, or to the two of them as trustees of their trust, okay? So I also want to dive in a little bit into a question that we get a lot here at the office from our clients or prospective clients, which is gifting property through a deed during your life or gifting property through your trust. So for example, let's say that there is an older father that comes in, he has an adult daughter, and he says, I just want to quitclaim or grant this property here to my daughter so it's a very smooth transition when I pass away. One thing that we try to make these clients aware of is capital gains tax. So what that means here is, let's say for example that dad purchased his home in 1999 or 1990 and that home was worth $200,000. Well, now it's worth $1 million. If he transfers that property during his life to his daughter and she receives it at that $1 million rate, then there's going to be an $800,000 gain that she'll have to pay capital gains tax on, right? There's that big shift. The difference here, on the other hand, is gifting property through a trust. So for example, if my trust says, upon my death, my trustee will distribute all of my assets to my granddaughter, Bianca, right? If that's what the case, then receiving property through the trust here allows for a step up in basis. That basis is $200,000. It'll be stepped up to $1 million. Okay, so there won't be a big capital gains tax exposure there if you're transferring it through a trust. Another item we like to point out here with trust here, a feature of a trust, is you can still actually provide for a charity that you want. So if you have a charity in mind that you want to provide for, but you also want to provide for your children or family, then we can do some strategic planning here that says, for example, if you have an IRA, a tax deferred account, maybe grant that over to a charity so that your children don't have to pay income taxes on that, and then allot all the other assets to your children there. So again, just some strategies there. I also wanted to dive in a little bit into what our comprehensive estate plans include. So the plans that we offer here are will include the trust that we've discussed, and then something known as a pour-over will. So a lot of times I get this question, what's the difference between a trust and a will? And it's a great question. So really the trust is the document that helps you avoid probate. If you just have a will, you still have to go through probate. The reason for that is a will cannot hold title. You can't hold property under a will, solely under a trust. So then the question comes up, well then why are you creating a will for me if you just said a will does not avoid probate? And the reason for that here is this pour-over will works together with that revocable living trust. So think of the trust here as a treasure chest, and during your life you're adding your assets in that treasure chest here. Think of the pour-over will as a net underneath that treasure chest. And let's say later on you open up a brokerage account, a checking or savings, and you forget to add that account into your trust and you don't name beneficiaries on the account. Well, that will is going to have language that says, if there are any assets that fall out of my trust, this will, this net, will catch that asset and pour it back into my trust. So they work together here, revocable living trust and pour-over will. We also create, and this package will include a financial power of attorney. So these are going to be things that you can't necessarily put in a trust. For example, if you have a phone bill, a credit card bill, an SDG&E bill, or maybe only your name appears on the account, and you want to grant somebody or an agent access to be able to speak on your behalf. That would be the financial personal power of attorney coming in. Again, also healthcare documents, so that will be who you want to appoint as a healthcare agent, again, to make any healthcare decisions on your behalf. And then we also include a deed here to be able to transfer your property from your name to your trust name, okay? So hopefully you found this to be educational. I feel like I spoke really quickly, but Thank you for taking the time here to come in. I appreciate it.